Haralambous and the Hertfordshire Constabulary.
May it please my lords,
Morning.
my lady. As in all closed material procedure cases, there will be no easy or comfortable outcome in this case. If the appellant is ultimately correct and the process requires disclosure of evidence relied upon, there may be some damage to the public interest in the investigation of a suspected crime. If the respondent or the interveners are correct and secret evidence is possible, there will be damage to the rule of law and the principles of natural justice generally. This case does not require these difficult interests to be balanced by this court. The hierarchy of them is already set. The starting point for any closed material procedure case must be al-Rawi. The common law principles of natural justice are so important, such a fundamental position in the operation of the rule of law that they cannot be abrogated without express statutory authority. If some other interest is to be accorded priority over them, it's for Parliament to so legislate. And pursuant to the principle of legality, Pearson-Sims principles, it must do so by express language or necessary implication, that is to say, unambiguously. So the first issue in any closed material procedure case, including this one, is to ascertain what Parliament has in fact done. My submissions to this court this morning will cover three essential chapters. This will be our first. It's not going to be straightforward because, of course, it requires consideration of the position of, firstly, the magistrate on a Section 8 application. That's issue A in the Statement of Facts and Issues. The High Court on judicial review, issue B, Roman 1. The Crown Court on a Section 59 application, issue C. And then back to the High Court on judicial review again, issue D. If the result of all of that is that the respondent is correct and that Parliament has provided for closed process in all four of those fora, then the second broad issue, my second chapter, is this. Does the fact that Article 6 is in play here have any impact? In particular, does Article 6 nonetheless require an irreducible core level of disclosure, whatever Parliament has sought to do? That's issue E. Put otherwise, is this one of those cases where Article 6, rather than Parliament, dictates the hierarchy of public interests and elevates the rule of law, the principles of effective participation, equality of arms, back to the fore?
You can't say whatever Parliament has decided, can you? I mean, unless you're thinking in terms of a declaration of incompatibility.
If Parliament has expressly
or by necessary implication decided,
enacted, my lord, yes.
Decided that this system will only work if you have no disclosure, then that leaves you with a declaration of incompatibility.
Well, if that's the last resort, yes, but the primary duty, of course, would be the duty to read down pursuant to AF number 3. If, however, the result of all of that is that in at least one forum the appellant is correct and there can be no completely secret evidence, that's to say either no closed material procedure at all, or that Article 6 irreducible minimum disclosure must run in one of our four forum, then the third broad issue is what are the consequences for a case then where the state is unable to disclose its evidence for reasons of public interest. That is to say, does Carnduff and Rock roam in the criminal field? That's issue B, Roman 2. I've rearranged them and I intend to address them in that order rather than the order that they appear in the Statement of Facts and Issues. So firstly, jurisdiction. Recalling, of course, that the appellant need only establish that closed process is impermissible in any one of the four arenas that this case passed through.
Can I just ask, the premise of the whole argument is that the legislation passed by Parliament after Al-Rawi and Tariq does not apply in this context. Do we have it somewhere just to see what its scope is?
You don't have it yet. It was omitted from the materials. It's the Justice and Security Act 2013. I'm going to come to it relatively quickly, but my Lord's absolutely right to identify that it doesn't appear in the materials we have. Section 6 is where Parliament reacted to Al-Rawi in the context of judicial review, enacted a closed procedure, but expressly excluded criminal causes or matters from that by Section 6, subsection 11.
Thank you.
So, my Lord,
if this were, if this you've shown us, or you've mentioned in your case, some cases on different statutes dealing with search warrants in the context of revenue and
yes.
customs, they would count as civil proceedings, would they?
Potentially, yes.
So they would be saved by this legislation, or covered?
Some would. Coombs would probably be a civil case. Yeah. Rossminster and Williams, perhaps not, because they were production orders, search warrants brought in pursuance of tax fraud allegations.
They don't necessarily lead to crime. They can lead to penalties. And
the key for the purposes of determining whether a matter is a criminal cause or matter is, of course, the nature of the underlying investigation. If it pertains to a criminal investigation, it will be a criminal cause and matter. That's the result, broadly, of the Panesar judgment.
You don't know at that stage necessarily, I imagine, if you're the tax authorities, what course you're going to take. Anyway, those are interesting questions, but you say what's clear is that the present are proceedings in a criminal cause or matter.
Absolutely. And I don't understand there to be any issue about that. Jurisdiction, what I would like to focus on initially, and firstly, is the jurisdiction of the High Court on judicial review of a search warrant. That's our second.
What is the criminal cause or matter?
Sorry,
Just before we leave that last proposition, what is the criminal cause or matter?
In this case, it would either be the search warrant application is a criminal cause. That is itself a criminal cause or matter, and the Section 59 application is itself a criminal cause or matter because it pertains to an underlying criminal ongoing investigation.
I see. Right.
Judicial review in the High Court of a search warrant, issue B, Roman 1. I focus there first because the answer here is potentially going to inform and feed into the other questions of jurisdiction. It can inform and feed backwards into the powers of the magistrates if one takes the view that law cannot have intended for the magistrate to make orders that are inevitably going to be quashed, and it could potentially feed forward into our consideration of Section 59, assuming the idea of a notional repetition of a Section 8 hearing is valid. The starting point, of course, is Al-Rawi. It applies to judicial review. There are three broad issues here that we don't understand to be in dispute on the face of the respective cases. The first is that Al-Rawi applies to judicial review. The majority said so in terms. Lord Dyson, paragraph 62 in particular, but proliferating throughout the judgment, paragraphs 39, 67, 69. The remainder of the majority not disagreeing with that proposition. In fact, Lord Clark, in the minority in Al-Rawi, would also have the same view, paragraph 170. The issue has been considered since AHK in the Divisional Court at tab 37, paragraphs 80 to 87. Judicial review attracts the Al-Rawi principles. Of course, as my Lord Mance has already observed, the position in that particular case was then reversed by the Justice and Security Act 2013, but not with regards to criminal judicial review such as this. The second broad issue upon which we don't understand there to be any dispute is that Al-Rawi applies to the criminal process just as it does to civil process. That's unsurprising, given that the criminal jurisprudence, notably Davis, was a significant source of the principles of natural justice which informed Al-Rawi. And Al-Rawi has been applied in the criminal context by this court in B Sky B, production orders, and B against Westminster, extradition. The third matter that appears from printed cases is that neither the respondent nor the intervener seek to uphold the reasoning of the divisional court in this case as to how it concluded that Al-Rawi does not apply to criminal judicial review. Paragraph 39 of the divisional court, where it wrongly held that the cases concerning right of access to evidence, that's Cronin, Energy Finance, Bangs, are not, so it said, linked to judicial review, and that challenges to search warrants were in fact brought by other judicial means. That, for the reasons we outline in our case, paragraphs 41 to 42, is manifestly wrong, and we don't understand the respondents or interested parties to make any case to the contrary. The argument of the
Which paragraphs in your case was it? Paragraphs
41 to 42, my lord.
Thank you.
Arguments of the respondent and the intervener is different and, we would observe, novel. Their argument now is that Bank Mellat number 2 applies. Of course, in Bank Mellat number 2, the majority of this court held that this court, the Supreme Court, considering an appeal from a closed procedure, could, under Section 40 of the Constitutional Reform Act, and the wide jurisdiction conferred by that, supported by Supreme Court rules, share the like powers to consider closed evidence on an appeal. That decision, per Lord Hope, crossed the Al-Rawi Rubicon and permitted judicially created closed procedures. Whether that's right or not matters not here. But it is fair to say that the decision in Bank Mellat has been liberally adopted by appellate courts in other contexts, and broadly, regardless of the terms of the statutory powers on which given appeals are premised, or the safeguards there available. Incidal at tab 66 is an example of Bank Mellat being applied to a criminal appeal. Some would argue that what Lord Brown called in Davis the creeping emasculation of the common law principles has been set in train. It's not the purpose of the appellant on this appeal to seek to swim in those waters. The target of this appellant is different and discreet. The target of this appellant is to argue that Bank Mellat principles do not attach to judicial review. Judicial review is not an appeal. There is nothing in the fabric of the common law, or even the Convention, that requires there to be an appellate review, a second level of decision-making in any context. Whether or not appeal powers exists is purely a matter for Parliament, just as it is a matter for Parliament to determine the extent of any appeal powers, whether they carry suspensive effect. And where Parliament so provides for powers of appeal, then, depending on the scope of the powers adopted, then on its broadest application, Bank Mellat implies into that decision a concurrent power to consider closed process where necessary to do so. That's appeals. Judicial review is fundamentally different. It stems from a different font. It exists for a different purpose. There is ample authority to this. Gibbs, in our materials, page 804, is but one. It stems from the same common law fountain that the rule of law and the principles of natural justice stem from. Those principles that produced al-Rawi. It serves as a check on executive decision-making or decision-making by administrative bodies or inferior tribunals such as here. It is an important constitutional protection. It exists from a time long before closed process was even in contemplation of Parliament. It's unsurprising entirely that Bank Mellat contains no suggestion anywhere that it should apply to judicial review, whether civil or criminal. And what al-Rawi tells us is that the common law jurisdiction from which judicial review springs, including its inherent jurisdiction, is subject to common law checks and absent statutory authority to the contrary. And insofar as judicial review is now regulated to some extent by the Supreme Court Act, Section 81, then it does well to recall that the common law duty of fairness is implied by the common law into acts of Parliament. It is attributed to the parliamentary intent, absent express parliamentary intervention to the contrary. Insofar as, therefore, the issue of judicial review is regulated in part by statute, the court must begin its analysis of the statute with that in mind, and the appellant's submission on the Supreme Court Act and Section 81 is that it doesn't even begin to resemble the terms of the Constitutional Reform Act, powers that were relied on in Bank Mellat. There is, in short, nothing in Bank Mellat or broader principle that requires judicial review to be approached in the same way as a statutory appeal. The right to apply for judicial review is here the right and the only means to have the exercise of administrative, executive, inferior tribunal decision-making assessed by a superior court. It's right to observe that judicial review does not run as freely in the criminal as the civil context. The Supreme Court Act excludes, for example, judicial review in relation to matters pertaining to trial on indictment. It does that because, generally speaking, the criminal courts have powers to deal with issues that arise in that arena. Not so here. The only means or judicial means capable of dealing with the legality of a search warrant is judicial review. There's ample authority to that. It includes, for example, Good and Chowdhury that are set out in our printed case. All of that, of course, means that the efficacy of judicial review is, as the authorities repeatedly emphasize, crucial in this context. That, in short, was accepted by the divisional court in this case. It's the only means of deciding substantive rights here, Article 1, Protocol 1, property rights, or Article 8, privacy rights, that are in issue between, on the one hand, the police, the applicant for the search warrant, and on the other hand, the criminal suspect. It's materially different from the situation envisaged in B Sky B at paragraph 28, determination of a dispute between the police on the one hand and somebody else, a witness, for example, with no substantive rights being determined. It's for the purpose of ensuring the effectiveness of this judicial review process that the common law has established the concomitant right to sight of the materials, the evidence placed before the magistrate. Energy financing, paragraph 24, subparagraph 10. That does no more than reflect the inter partes nature of judicial review and respect the common law principles of natural justice in play in that judicial review. That right has been steadfastly protected by the courts, both here and abroad. The cases in which the courts have considered that are set out in our case, paragraphs 24 to 25. That right is subject on the authorities only to principles of PII, that is disclosure or non-disclosure of unused materials. I'll return to PII in order to explain its proper function in this context.
Am I right? These authorities are all authorities where the common law has developed procedures which are not expressly mentioned in the statute.
Absolutely.
Yeah.
The common law, incorporating, as we know it does, principles of natural justice, has developed procedures to reflect natural justice in the context of what is an inter partes judicial review process.
You cited some criminal procedure rules, which no doubt you'll come to at some point, but they're obviously subordinate legislation, but they do appear to postulate that some information will be withheld, and in due course you'll come to that.
I promise I will.
Has any case considered their interrelationship with this common law duty of disclosure?
No, not that we're aware, but by way of headline, my Lord, the rules to which my Lord has referred deal with PII and the process of PII. That's withholding.
I see. If they're just dealing with disclosure. Ordinary PII, I've got
absolutely,
yeah.
With one exception, and that's an exception that applies now in the Section 59 Crown Court context. The rules have gone one step further and provided since April of this year for a closed process, excluding parties from the hearing. And I'll deal with the vires of that, if I may, when we come to that stage of our support. But broadly speaking...
Well, that's the one you quoted, isn't it? Since 3rd of April 2017. It's the one you quote in paragraph 17 of your case, I think, is it?
Yes.
I mean, are you saying that that's, logically, maybe you are saying that that's ultra vires?
I will do in due course. It's rule
4739(3)
that goes further than all the other rules.
Yes,
the other rules dealing with PII, sub-rule 3,
yes.
I accept, is a closed procedure rule. It's not directly an issue in this appeal because it's been introduced long after the Section 59 hearing in our case, but for what it's worth, we will submit that it's ultra vires. So coming back to judicial review and observing simply that there are no procedural rules to turn to for closed process in judicial review. The common law, pursuant to its pursuit of natural justice, has developed rules to give effect to that in judicial review proceedings. In this context, that's sight of the evidence, subject only to PII. Closed procedure rules or a closed materials procedure, that is to say withholding of evidence or secret evidential hearings, would strip judicial review of all meaning in this context. It would effectively immunize executive decision-making or the decision-making of the inferior tribunal in this case from judicial review.
Completely?
I can't say completely because, of course, there would be a judge sitting in a closed court looking... Might, possibly, but the fact that a judge can review the materials for themselves is no substitute for closed material. There is no makes no difference principle at play in closed material cases. AF number 3, paragraph 60 to 65, Lord Phillips, and 84 to 85, Lord Hope. And in any event, the makes no difference argument is for the reasons detailed by Lord Kerr and Al-Rawi, paragraph 93, based on a false premise.
So it's really stripped the applicant of judicial review of an essential...
It certainly stripped the applicant of any participation in it realistically whatsoever, but it also strips the judge of their powers to do what is right and to perform their functions. So, for example...
Because he doesn't hear the representation.
He doesn't hear the representations at all. He's got no law drawn to his attention in assessing the statutory conditions. Now, he may be taken to know the law himself, but
Well, no, that's not right, is it? So don't overstate it. Surely, there's absolutely no difficulty, even if it's a closed material procedure, in the applicant drawing the judge's attention to the law, is there?
not if he doesn't know what questions the judge is considering.
I see.
The law as it applies to a specific issue under the Police and Criminal Evidence Act will be specific. The width of the warrant, the access conditions to it. If the applicant doesn't know, as he doesn't know in this case, what the problems that potentially are with the warrant, he can't draw the judge's attention to the relevant law as pertains to that particular issue. But the problem's a wider one. Without knowing the information that the judge is acting on, he's not able to demonstrate that it's misleading or inaccurate or misleading in that material facts have been omitted. And what shines through from the case law on search warrants is the importance of the duty of full and frank disclosure. There are legion cases where, unfortunately, that has been misunderstood by both the applicant and the judge, and the judge simply isn't in a position to understand whether it's a duty that's being complied with if he isn't being presented with all the other facts that have been omitted by the applicant, and that can't happen in a closed material process. Neither on the authorities is the fact that, and for the same reasons, a lay justice in the first place issued the warrant. There's authority adequate to that. EFT, energy financing, paragraph 24, subparagraph 10, makes that elementary point. The position is, and we do say, closed material procedures in the judicial review context strip it of all effective meaning. The position that you arrive at is what Lord Steyn in Roberts called a phantom hearing emptied of all meaningful content. Lord Bingham in Davis taking blind shots at a hidden target. And Lord Hope in AF3, the stuff of nightmares. Prior to Al-Rawi, when secret evidence in judicial review was outlawed, absent express parliamentary approval, the House of Lords fully recognised that the effect of all of this was to strip judicial review of all meaningful content. That's what, for example, the Privy Council in Williams, tab 13, says in terms. At page 361, the effect is, for practical purposes, the issue of the warrant is often likely to be incapable of effective review. And at 365, the courts are incapable of protecting the substance of the individual right. And it was with frustration, paragraph 365, Lord Hoffman felt compelled, before Al-Rawi...
Sorry, paragraph 365?
No, forgive me, it's page 365.
Well, I think he said although courts may sometimes feel frustrated.
Yes.
Yes.
If you wouldn't mind giving the electronic page number as well, please.
Oh, of course.
I think in this case it's 766.
So,
that's all right.
Williams is...
764.
Yeah.
Begins at 750, page 361.
No, that's not electronic.
Would
It's 760. Is 760.
Yes.
361 and 365, 764. What was the passage on 760? Which,
On 760, my lord,
where is it?
it will be about a
Yes.
third of the way down the page. But these limitations on the exercise of judicial
yes.
control over the decision of the justice to issue the warrant make it all the more important that he should make the decision with the greatest care.
Yes. Right.
He has the responsibility of fulfilling the requirements of the statute, the effect of which is that for practical purposes the issue of the warrant is often likely to be incapable of effective review. And then next paragraph, the courts just have to do the best they can. At 365, page 764 manuscript, middle of the page, courts may sometimes feel frustrated by their inability to go behind. And further down, that they remain incapable of protecting the substance of the individual right conferred by the Constitution.
But they do go on to say, their lordships think it would be wrong to try to compensate by creating formal requirements, which the statute doesn't impose. In doing so, there's a risk of having the worst of both worlds.
Yes, but of course all of that was before Al-Rawi and the true import of the requirements of natural justice and their hierarchy in...
And it was about formal requirements, anyway.
Of course, what the Privy Council was doing there was reviewing the position that had been reached in Rossminster. So tab 7, manuscript 689, internal page 1022, Lord Scarman speaking for the majority. At the top of the page, it's the duty of the courts to see that it, that is to say the power to issue a warrant, is not abused, for it is a breathtaking inroad upon the individual's right of privacy and right of property. Important as the public interest in the detection and punishment of tax frauds, it is not to be compared with the public interest in the right of men and women to be secure in the privacy of their homes, their offices and their papers. Yet if the law is that no particulars of the offence or offences, then that was ultimately the conclusion that the court reached. The warrant there, the scheme there required no particulars of the offences to be given in the warrant. How can the householder or occupier of premises hope to obtain an effective judicial review?
So he was a dissenting judgment.
Lord Scarman wasn't dissenting. It was Lord Salmon dissenting.
Right, Salmon.
This is the majority speaking. Therefore, with regret, yes, the courts have to accept that the Act is as it was, and the prospects of immediate judicial review of the exercise of the power is dim. So we submit that we don't overstate the proposition that judicial review in the criminal context, and in this criminal context, coupled with closed material procedure, does strip judicial review of all meaningful content. Our submission is that Al-Rawi now requires a different approach to be taken unless Bank Mellat applies, which it doesn't. And in ascertaining the parliamentary intention for Bank Mellat purposes, it's obviously significant that following Al-Rawi, in 2013, Parliament moved to create closed process in judicial review, but civil judicial review, and albeit with safeguards. Parliament patently can't have perceived then that closed process was already implicit in its judicial review powers. And it's equally significant that it then deliberately excluded criminal judicial review from that and has not altered that position since.
And were they thinking of this sort of situation? I mean, they certainly weren't going to overrule Davies or hold that you could convict people on the basis of evidence which was closed, but a search warrant to get real evidence, which might be used in criminal proceedings, would have to, and the evidence would have to be disclosed in public and examined, might be thought to be a different thing. This is sort of procedural step, admittedly invading somebody's property.
Yes. Our submission, my Lord, is that Parliament must have conceived that criminal judicial review was in a different league to civil judicial review. It's prepared to make provision for closed process in civil judicial review, but stepped back from it in the criminal context.
Yes, what I was really asking was, we have no reason to believe they focused on this type of case, though.
No, but this type of case is plainly within the category of cases that it has excluded.
You would say also, I suppose, that there was a separate legislative reaction to Davis in relation to anonymity of witnesses.
The Davis issue doesn't arise in a judicial review context.
Yeah.
So yes and yes. Parliament reacted differently to Davis, and again, it did not react in that way in this arena. Insofar as the position of other jurisdictions is helpful here, and perhaps can be taken to have informed what Parliament was doing in the criminal judicial review context, of course, you have in your materials the position as it pertains, for example, in Bermuda, the case of E, tab 52, paragraphs 40 to 20, an application to set aside an ex parte production order in which Al-Rawi and B Sky B were applied. The disclosed materials must thus contain sufficient information for the court to satisfy itself in open adversarial process of the legality of the warrant. So the position we say in judicial review is clear and established. The judicial review proceedings must be open, they must be adversarial, and they must fully reflect the principles of natural justice. That's our starting point. Our submission to this court is that when you approach this case through that door, that then informs how one views the other jurisdictions that we are concerned with. So first of all, and the next forum that we need to discover is the Magistrates' Court. If closed process is permissible in judicial review, then no issue arises here. The ex parte character of the Magistrates' Court will carry through. But what if there is, as we submit, no closed process in judicial review proceedings? What does that mean for the antecedent Magistrates' Court process? And in a sense, one might think it doesn't matter. The warrant's going to be quashed on judicial review. The appellant here gets what he wants. We don't need to concern ourselves with whether there are implied limits on what ought to have happened at first instance. But as we will see, it does matter. Judicial review is not necessarily the end of the matter. There's a Section 59 process waiting in the wings, which on one view will be impacted by what happened in the Magistrates' Court rather than in the judicial review process. So what if there is no closed process in judicial review, as we submit there cannot be? It cannot be suggested sensibly that the law envisages a procedure by which a warrant, doomed from the outset to be quashed on judicial review, may be lawfully issued and executed. This isn't the tail wagging the dog. There is no conceivable purpose in creating or facilitating a power to issue a stillborn warrant, especially as envisaged by the intervener, where it would create theoretical, unvirtuous circles. Magistrate issues, judicial review quashes, magistrate reissues, judicial review quashes. None of that makes any sense at all. It must follow from that ridiculous position that the absence of closed process on judicial review must feed back into the predicate powers of the Magistrates' Court. There must be some implied limit on those powers. That is to say, to issue warrants only on evidence which can subsequently be disclosed in the open and adversarial judicial review proceedings. And the fact here that the procedure before the Magistrates' Court on a warrant application doesn't look or feel like a closed procedure, closed material procedure, supports that proposition. Experience shows that if Parliament authorises a closed process, it does so carefully. Take, for example, the Counter-Terrorism Act in Bank Mellat. It confers upon the court a jurisdiction or discretion to go into closed session, a discretion which permits the court to do only what is necessary in accordance with the entreaties in Bank Mellat. Parliament confers safeguards in the process, special advocates, gisting of materials. It confers procedural rules to accompany it. Nothing like that here in the Magistrates' Section 8 application process. All that exists here is the ex parte blunt instrument. And the fact that that doesn't look or feel like a proper closed process that gives effect to and is cognizant of the common law requirements of procedural justice must support the appellant's primary position that the true import of that process is merely to delay the point of participation of the individual. It has no wider import. It's only a single stage in what Parliament regarded as an overall process that included the inter partes judicial review. And it's wrong to view it, as the Divisional Court did in this case, in isolation and without that wider litigation context. And if that's right, of course, then we're back to the beginning. It's simply not a closed material procedure in the manner envisaged by Bank Mellat. Now, the respondent argues, supported by the intervener, that the obligations to weed out the material which can and can't be disclosed at that initial stage of the case is an impracticable one. We're talking about a busy court, inexperienced police constable, a lay justice, situations of relative urgency, perhaps getting the justice out of bed. They say it's nonsense to have to work out at that stage what is disclosable and what is not. That is a submission which, in our submission, underplays the importance of the process and the responsibilities of the magistrates. It's never an in-out rubber stamp affair. The law requires the police and the magistrate to approach warrant applications in a manner commensurate with what is at stake for the target. The law is replete with cautions to that effect. On a more practical level, that which the respondent argues against is in fact precisely that which criminal procedure rules provide for. So back, please, to the criminal procedure rules. Dealing only with those at the moment that deal with Section 8 applications, Rule 47, Part 47, Rule 26, subparagraph 4, page 533.
Sorry, Rule 47.
47.
26.
Part 47, Rule 26.
Yes, it's 554.
Subparagraph 4.
554.
Yes. And subparagraph 4.
Yes. Where the application includes information that the applicant, that's the police, thinks should not be supplied under Rule 5, it may set out that information in a separate document marked accordingly, and in that document explain why it thinks that the information ought not to be supplied. That is a rule that was in force at the time of this warrant, albeit situated elsewhere in the criminal procedure rules as they then stood. It represents the sifting process that has to be done for PII purposes. From the body of information placed before the magistrate, the PII materials, the sensitive materials, have to be sifted from the disclosable materials. It's simply not the case that the magistrate should consider, quote, all of the information without being concerned with the issues of PII and disclosure. That's, of course, what the divisional court thought in this case.
Is this rule in a form which is different from a previous form?
No. It used to be Rule 6, or Part 6, Rule 30, Paragraph 11.
63011.
Yes.
Thank you very much indeed.
The police are not legally trained. They are not in a position to assess whether information satisfies the legal conditions. The criminal procedure rules allows them to present everything to the magistrate. The job of the magistrate is to determine whether on the open material there are sufficient to satisfy the requirements of the legislation. The scheme considers the magistrate capable of making such an assessment. This is perhaps an appropriate moment to deal with PII, because these are rules that are designed to deal with PII situations. PII is immunity from disclosure of unused materials. It is a completely different creature from closed procedure evidence. Of course, before a magistrate, it is permissible for the police to appraise the magistrate of PII materials, materials on which it doesn't rely, such as, for example, materials to discharge its duty of full and frank disclosure. It doesn't rely on those materials, but it's important that the magistrate is aware of them so that it understands that its duties have been fulfilled.
Yes, but 4726(4) is material that's relied on, isn't it?
It's material that's before the magistrate,
Yes.
such as PII materials.
Do you say that it should be read as meaning that such information, if supplied to the magistrate, cannot be relied upon? You presumably do.
Absolutely.
You have to, don't you?
Yes, absolutely we do. And that must be the import of the rules. Of course, at this stage, the limitations on the magistrate's jurisdiction flow from the problems that arise at the next stage of the case, and the fact that it's fully open.
I mean, it's ambivalent, the rule, isn't it?
Yes.
That paragraph as to what it's talking about.
And of course, we do say that and the other reading of it, that it permits closed process, would be ultra vires. There is no vires in the enabling act here to create, by virtue of rule-making provisions, a closed material process that cuts across the common law principles of natural justice.
But have we got Rule 5.7? I couldn't find it.
We do have it.
Because that's about the subsequent process of somebody seeking
Yes.
to see the material and somebody else objecting, isn't it?
It's tab 81, page 2785. So this is the rule that applies after a warrant has been executed.
Is this in the context of warrants?
Yes. So 5.7, Rule 1B, the person affected by a warrant issued by a court is entitled to seek the information relied upon before the court. Now, in this context, that is in the context of commencing judicial review proceedings. So this is all at one with the common law rule that has sprung up, that for the purposes of preserving the efficacy of the judicial review process, there is a right to see the evidence relied upon below.
Yes, I'm just trying to see where it takes us in terms of interpreting the original provision to which we referred, 47.26.4, which is ambiguous as to whether you just file everything, whether you should yourself exclude, you the applicant, you should yourself exclude the material which you consider should not be disclosed.
The process as we understand it, that would pertain before a lay justice dealing with an application is that the police would bring the box of materials. In that box, they would have divided up that which is disclosable and not disclosable. The not disclosable section of the box is PII. It can't be relied upon by anybody at any stage, but it's there for the judge to look at if she wants to. The remaining bit of the box, the disclosable materials, is the evidence. And it's that body of material that the judge would then assess by reference to the statutory conditions.
So the purpose of putting the non-disclosable material before the magistrate is simply to comply with the obligation on the part of the applicant for the warrant to make full disclosure to the
That's one obvious reason for putting PII.
Why else would it be there at all?
If you're relying on a confidential source, the magistrate would want to know, for example, and this isn't a requirement of the Act, but the magistrate would want to know that you've properly assessed the reliability of your source, and so you would be placing before the magistrate...
That's full and frank disclosure. There's an obligation, specifically, isn't there, in Rule 47, to disclose anything which may undermine your
Absolutely.
application.
So that's Rule 47.26.
Yeah.
E, and that
But apart from that, why else would the material be before the magistrate at all?
there's no other reason for it to be before the magistrate. There are aspects of the materials that would be before the magistrate that one can see would be sensitive and not central to the issuance of the warrant. For example, the identity of the officer making the application. There may be an interest in keeping that secret. It's required by the criminal procedure rules to be disclosed to the magistrate, but it's not part of her function in assessing the legality of the warrant or the date when the warrant might be expected to be executed. Rule 26E requires the magistrate to be told that.
But to take your example of informing the magistrate that the application comes as a result of information received, is the magistrate not involved in an evaluative process when she or he is asking the question, well, have you checked the reliability of this individual?
Yes, and if the answer to that is no, then the magistrate won't issue a warrant.
No,
but
my point is this not material which is relied upon by the applicant for the warrant?
In the sense of discharging your duty of full and frank disclosure, then yes, but it's no part of the requirements of the Act that there be an assessment of the reliability of the source. It's simply logical and common sense practice that the magistrate would want to know that the information before her is reliable.
Yeah, but she wants to know it because the information is the basis of the application.
Absolutely, but it's the information that's the basis of the warrant. If subject to it being undermined in any way by the duty of full and frank disclosure, it's the information, the intelligence.
Your case is that if it's a confidential informant, somebody whose life is at risk, somebody who's too close to the object of the search warrant or whatever, then that is material which cannot be relied upon and ought not to be before the magistrate at all.
No, the intelligence can be relied upon.
Can it?
Well, it would have to be because
How do we go about that?
The product of the intelligence is the factual foundation on which the magistrate acts. How that intelligence came to exist is a different question.
Well, yes, of course, if the antecedent bit of confidential information gives rise to some tangible additional fact which can be proved otherwise, yes, but the crunch point in these cases surely is likely to be, in many of them, that the source of the information in this building, there may well be large quantities of gold bars or drugs or whatever, has come from a source which cannot be disclosed. Yes. Now, if you're right, it follows, does it, that that's simply something that you can't put in front of the magistrate because you're never going to be able to rely on it in future.
Well, if the source is inextricably bound up with the information in question, then it's going to create problems. But it does, as we will see.
Well, what else is the policeman supposed to say? I've got information, but I can't tell you where it came from.
Yes.
That there are lots of gold bars in this house.
Absolutely. And it's the information that the recipient of the warrant needs to know to be able to understand the scope of the warrant.
But forgive me, how can the magistrate assess that?
The magistrate can assess, the magistrate can assess for the statutory conditions whether the information, there are gold bars, satisfies the statutory conditions, reasonable grounds to suspect criminality. What the magistrate will also wish to do is to assess the reliability of that evidence, because if it's unreliable...
Right. Yes, I see. So it's perfectly all right for the policeman to go along and say, I've got information, but I can't tell you where I've got it from. Is it?
That's all right.
Really?
It's not ideal, but at least it's...
It can't be, can it? Because the source is something which someone, anyone wishing to consider whether to act on information would want to know about, wouldn't they? And anyway, I mean, let us just take your hypothesis that it's sufficient to disclose information that there's gold bars there. That could immediately identify
yes.
the informer, couldn't it?
Well, that's...
There could only be one other person in the world who knows that there are gold bars. What we understand, what has been said, is that these warrants are executed by policemen who, on the face of it, make clear that they don't know what they're looking for, although in fact they do. When they find it, it appears to be a surprise, and they don't give away the source.
Right. I'm not sure that we would agree in the modern world that the fears that are articulated in relation to that are necessarily well placed. An allegation of domestic assault on a wife in a bedroom, for example. I don't think anybody in the modern world would sensibly think that information of it coming to the attention of the police would necessarily have come from the wife herself rather than a neighbour or a doctor noticing bruises or conspirators in a cabin.
Obviously you can postulate such a case, though, very readily in certain contexts.
And what's important for our purposes, this is the first case in 30 years where that position is said to have been reached.
Well, so it's the first one in which it's been challenged. That's not going to get us very far. But what I'm after is what the policeman is supposed to do. Because you may be right. If you're right that Haralambous simply feeds back into the original process because it can't be defended in judicial review without disclosure of the material and so on. If you're right that Haralambous feeds back, what's the policeman supposed to do?
It's not so much the policeman. The policeman will come to the magistrate with his box of materials, having divided out what he thinks is sensitive and what isn't sensitive.
And then but he mustn't rely on anything that's in the sensitive box.
But it's the judge. Right? She can't rely on what's in the sensitive box.
Therefore, nor can the policeman. Come on.
No, understood. So there can't be evidential reliance on the PII materials, because that cuts across
on anything that cannot subsequently be disclosed.
Absolutely.
I mean, the reality is that the police would be faced, or investigating authorities would be faced with a choice. If it was sufficiently serious, they might decide to go ahead. Maybe the magistrate should spot what's happening and say it's not good enough. But if they went ahead and did get a warrant, they might then get material they could use on conviction. But on your case, they wouldn't be able to defend the warrant, and they'd be liable in trespass.
But if the warrant is quashed, they also don't get to keep the materials.
So if they don't keep the materials, then that's the end of it.
And therefore can't use it. It would put them in exactly the same, well, not exactly, in an equivalent position to the position which arises in a criminal trial, is this right, where the direction is this piece of information for which you claim PII must be disclosed to the defendant.
Yes.
And that not infrequently results in the prosecution having to be abandoned.
And I'll come to that when we deal
So
with
it's
conduct
analogous
wrong.
to that, is it?
It is analogous to that. And I don't, although I have my doubts about how real this fear is, I don't shy from confronting it and assuming it might be a real one in a given case and is a real one in this case. But the reason we are at that result is because of Al-Rawi and because of the place that natural justice plays in the legal process as a whole and in the criminal judicial review process in particular.
I follow that. And one last thing, because I'm interrupting you, I know, but if the policeman's duty is to bring 2 boxes,
Yes.
the magistrate's duty is to look at, is to rely only, is it, on
Yes.
what's in the, as it were, the open box?
Yes.
Now, is what is in the open box include we have information to the effect that there are gold bars or drugs in this building?
It could. In a case where the police suspicions were founded on 4 different strands of evidential findings.
No. Come on.
Then,
Let's confront the
Yes,
likely real issue. There's one source of information. He's in the closed box because he's at risk if he comes out of it. Can you or can you not put in the open box, we have information that?
yes, you
not.
can.
You
It can be divorced from the identification of the source. I'm not trying to deflect, I think, my Lord's question. The answer has to be nuanced. There will be cases where the confidential source is not the only evidence and where the judge can just look at the rest of the evidence and still be satisfied.
That's
There will be
that's
cases.
the easy one. It's
Yes,
a difficult one.
and there will be cases where the information can be divorced from the source of the information. That disclosing the intelligence says nothing about the identity of the source.
It may not reveal the source, but how can it be evaluated by anybody unless you know what the source is?
But that's not the function of PACE. It's not for the judge to evaluate the source. Austin says that. It's the judge might want to, and good practice might lead a judge to question the reliability of the source.
Got to have reasonable grounds for believing.
Absolutely.
Well, how do you demonstrate that without demonstrating what your source is?
Well, in a case where the information can be divorced from the source, I have information that suggests there are gold bars in the house. That is my reasonable ground.
That's all right, is it?
Then the judge could conceivably go further. A sensible judge would want to check that the information comes from a reliable source. The reasonable grounds derive from the information, not the reliability of the source.
Thank
But I do confront the difficult case where conspirators in a cabin, the information can only have come from one possible source. And that is the difficult case. And the answer to that case is no warrant. And that's the price the law must pay in order to respect the principles of natural justice.
Before you leave the subdivided box, can I just ask what happens at the end of the appointment with the magistrate? Does the officer take away the material upon which reliance has not been placed, or is it kept by the court?
Well, we're talking about boxes, but in reality we're talking about a document that sets out the information. Yes. So the magistrate would keep the entire document, but it would be subject...
Okay.
In fact, there would be 2 documents.
Yes.
It was subject to the procedure in
Yes.
Rule 5.7.
Yes.
You said that applied to this case, but in fact it's said to apply only on and after the 5th of October 2015, so it wouldn't apply to this case, would it? So we ought to know...
I'm relatively sure that that's a rule that applied before then as well.
You better let us know.
I think the 5th of October is when the the new rules came into
While you're doing
effect.
your historical research, while you're doing your historical research, at some stage, not now, could you or somebody give us the origins of Section 8?
Section 8.
Yes, the power to issue a warrant. Where did it come from originally?
Certainly.
And in what terms?
Thank you.
Yes, I would like to see whether it relates in any way to the types of warrant in respect of tax and customs that you mentioned in the House of Lords cases, which you helpfully cited. Just one more question on 5.7. Surely this contemplates, rightly or wrongly, a closed procedure, doesn't it? If you look at subparagraphs 8 and 9 on memoristic 2786, they don't make sense, subparagraph 8 and 9, in relation to PII, do they? They seem to postulate that this is material which has been, is only for the court, 8b, and then 9 seems to postulate that you can have a hearing in part or in whole in the absence of the person who's applying for the information, where you hear representations about it. It seems it seems unlikely that they're just thinking of PII.
Well, what we know is that PII can take place properly and consistently with the common law principles of natural justice in private.
Yes, but this postulates that there's material which is only for the court. In other words, it's material which the court is going to rely on.
Which would be PII material, disclosure made to the court pursuant to your duties, but not to be made to the applicant.
But PII, as you rightly say, is quite different. What you're doing when you make a PII application is asking permission not to show it to the other side, and it's then not used by anybody.
But this is absolutely, and this is an application to withhold it. This is a statutory PII hearing.
Is it?
Well, I see. Well,
it reads differently depending on how one views the status of this material. But if one is to assume, as we submit, we're talking about PII materials, then what's being contemplated here is that the police are putting disclosure before the magistrate
right.
In order to discharge its duties. And when the target applies for the warrant, there's a PII hearing in the same sense of bounds.
Yes.
Well, except that this is all predicated on a subsequent application for information under 571, isn't it? Yeah. Okay.
Sorry,
Anyway, we ought to let you get on with your submissions.
Thank you. Our broad submission, of course, is that there's nothing in the PII process that permits reliance on PII material as evidence. The PII procedure is compatible with principles of natural justice, Al-Rawi, B-Sky B. And in the disclosure context, it contains a healthy dilemma, Lord Kerr, paragraph 96, in Al-Rawi, the incentive to disclose. Closed material is the opposite, it's an incentive to secrecy. Can I deal quickly then, if I may, with the Crown Court hearing? The situation here is that either with, on our facts, or without closed process, the warrant has been quashed. But the process here is unavowedly inter partes, so say the rules. It contemplates notice being given beforehand. Query whether Van de Peel, at tab 40, paragraph 98, was correct to contemplate an urgent ex parte version of this. There's nothing in the rules or the enabling act to suggest so, but the fact is here that this section 59 hearing was on notice inter partes.
So which paragraph in Van der Peel?
Paragraph 98.
Yeah.
Page? Oh, all right, we'll find it.
But doesn't the statutory structure invite the question, what would have happened on an ex parte application?
Well, that's the issue. The starting point is that Section 59 hearings are determinations of a list between two parties with interest in fundamental rights. The list here is, of course, more fundamental still than the one that existed in B-Sky B. So what's scope here for a closed process? There are only two routes. First is that Parliament expressly contemplated it or provided for it. No party suggests that that is the case here. It does now. Since 2017, we query the vires of that, but that's a matter for another time, not in time in this case. The second route, and the route advocated by the respondents in this case, is that Parliament has impliedly provided for closed process by the route that my Lord has just mentioned. So section 59, subsection 7, requiring the Crown Court judge to put himself in the notional position of a magistrate on section 8 application. Our submission is that there is no such notional carryover for three reasons. Firstly, it's not what the Act says. Section 59, subsection 7, asks whether it would be appropriate for the Crown Court to issue a warrant now. It uses the words it does, would issue a warrant, because, of course, but for section 59, the Crown Court has no other powers to issue one. But it doesn't seek to ask whether a notional magistrate would issue a warrant. Nothing in the Act permits, much less requires, the Crown Court to make its decision by reference to rules which govern the magistrate. Secondly, it subverts the whole purpose, or at least an essential safeguard built into section 59. That is the requirement for the police to prove its entitlement in open process to the warrant. That's Panesar, tab 56, paragraph 36. And thirdly, back to Al-Wari, abrogation of fundamental rights can only be implied from clear and unambiguous language of all the oblique situations in which a court has been asked to imply such parliamentary intent. And whatever one thinks of the decision in Bank Mellat, no implication so Delphic as this has ever been suggested to ground a closed process, much less upheld. I should add that the respondent appears to advance a further fallback argument under section 59, and that's that search warrants might constitute a new third exception to Al-Rawi, founded upon the interests of the informant in confidentiality as being distinct from those of the applicant in a fair trial and the police in the investigation of the crime. Thus, suggest the respondents there's a triangulation in the way of intellectual property rights or the rights of children. That, of course, can't be correct. If it were correct, it would have been an answer to B against Westminster. And as Lord Mance pointed out in that case, paragraph 31, the confidential source simply isn't at risk in reality. Either there exists a closed procedure in which they remain secret, or there doesn't, in which case the police will not disclose. It remains a two-sided issue as between the police and the target of the warrant. Lord
Ian
Mance,
Westminster as well.
tab 53, my Lord. The part of my Lord's judgment that deals with that is paragraphs 27 to 34. My Lord, Lord Hughes agrees at paragraph 52. Neither, of course, is there here any prospective trial in the pipeline competent to determine the legality of the warrant later in the litigation. The judicial review is the trial of this issue. So in our submission, the Section 59 hearing, regardless of what has gone before, is intended to be and has to be consistently with the principles of natural justice an open one. And even if that's not right, our fourth forum, judicial review of that decision, as before, is on any view an open inter partes procedure in which closed material process does not exist. That, of course, feeds back then into what the Crown Court can permissibly do for the same reasons that it does when considering a Section 8 warrant and a judicial review of that. So that's our first chapter, the issue of jurisdiction. What, however, if the Appellant is wrong about all of that, and a closed process is permitted in the sense of impliedly authorised by Parliament at all 4 stages. It's not the end of the discussion, because these are all proceedings that are governed by Article 6. They are determination of the civil right to property and to privacy. They involve state intrusion on fundamental rights, and the appellant is entitled to a fair hearing of the determination of that trial, that issue, the determination of their legality. So our second chapter, if there is, and Parliament has provided for closed process, does Article 6 make a difference to that? Article 6 procedural fairness rights are in play here. Parliament can legislate as it wishes, even deliberately unfairly, but by virtue of the Human Rights Act, its decisions are subject to Article 6 unless it provides otherwise. And that is to say that Parliament can legislate for closed process if it assesses that the public interest in secrecy outweighs the public interest in natural justice, but Article 6 can nonetheless operate to reverse that and reimpose natural justice above other public interests. So there are therefore cases such as A against UK and AF number 3, in which deliberately enacted closed processes are nonetheless ameliorated by Article 6. In such cases, at least where the decision is based solely or decisively on closed process, and I approach that, of course, with the degree of realism that I need to, bearing in mind the approach of this court to the issue of sole and decisive. It's not a straitjacket. It's probably better viewed here as a threshold. But in cases such as this one, where the materials are decisive or the sole basis on which the state interference is based, then Article 6 can require, not necessarily will, but can require that whatever Parliament has done, that the target needs to be afforded sufficient disclosure of the allegations, not the evidence, not the source, but the allegations, to be able to know the essence of the allegations, to be able to give instructions to his legal team to refute them if necessary, and to assess and effectively challenge the legality of the state's intrusion. The case law on this, I hope, can be quickly summarised. The first recognition of all of this appears in Roberts in this court, tab 20, a case under Article 5, sub-Article 4, because it involved detention. But the discussion was found to be premature on the facts because the parole board there had not yet taken its decision, and the court wasn't in a position to determine whether ultimately the decision was one that had violated Article 5. The issue came to the fore, however, in A against the UK, tab 24, paragraphs 218 to 220, where the irreducible minimum disclosure requirement was first unambiguously laid down by the Grand Chamber. Just for note, before then, Edwards against the UK, an entrapment case, had held that there can be no reliance ever on ex parte material. A drew back from that. Reliance on closed evidence is possible in principle, compatibly with Article 6, but subject to irreducible minimum disclosure. That then brought this court's decision in AF number 3, irreducible minimum disclosure in the control order context, notwithstanding there that the Parliament had built safeguards into its closed material process, special advocates and the like. What this court held in Tarrick, tab 35, at least by a majority, was that Article 6 is not uniform in its application. Not every case to which Article 6 applies will attract irreducible minimum disclosure. Article 6's procedural guarantees depend on the context in which it operates. They are points on a scale or a spectrum. The touchstone will generally be the nature and impact of the decision in question. So at one end, you have state-initiated intrusions on fundamental rights. Their minimum disclosure is required, pursuant to Article 6, and whatever Parliament has done. So A against the UK, Sher against the UK, where liberty is at stake, minimum disclosure is required. AF number 3, control orders where freedom of movement is at stake. Minimum irreducible disclosure is required. That's even the case, so says the Court of Appeal in Mohammed, tab 48, paragraphs 10 to 20, where the evidence in question is in reply to defence evidence rather than a case being made against him in support of state intrusion. Minimum irreducible disclosure is also required in asset freezing cases. Cardi and other CJEU cases cited in there. So that's tab 29, paragraphs 171 to 177. A against the UK, irreducible minimum disclosure applies to asset freezing. EU law here, the principles of EU law of procedural justice, effective judicial protection, run in tandem with Council of Europe, Strasbourg protections. Thus it is that in Tariq, my Lord Lord Mance, paragraphs 24 to 27, cited asset freezing as a clear example of a case within that privileged class to which irreducible minimum disclosure applies. So held the Court of Appeal in Mustafa, tab 39, asset freezing, and in Bank Mellat number 4, tab 61, paragraph 22, the court had no doubt that irreducible minimum disclosure applies to asset freezing cases. It also applies to expulsion of EU citizens, impairment of their free movement, case of ZZ, not in our papers but referred to in detail in Kiani, tab 60. It also applies, Bank Mellat number 4, tab 61, to financial restriction orders, restricting the access of a bank to its commercial market. What's common to all of those is state-initiated intrusion on fundamental rights. The targets of state action are all involuntary participants in that legal process. There can be arguments about the hierarchy of those rights, but Article 6, irreducible minimum, applies to them all. At the other end of the scale or spectrum are situations where the state is not intruding on existing rights at all, where the litigant is voluntarily part of the litigation, which he or she has initiated themselves in order to obtain something from the state to which they're not obliged to be given, and the state is not willing to give them. There, no minimum disclosure requirements are or exist for Article 6 purposes. And in this other class of case, out with the A against UK category, Article 6 permits, or even requires, this court, the domestic court, to balance the public interests in confidentiality, against fair trial, taking into account safeguards, and in this class of cases, you can end up with the situation of a fully secret, closed process, compatible with Article 6. So Kennedy, tab 28, Mr. Kennedy applying for relief, prohibition and destruction under the Human Rights Act for interception of communications, a right which didn't or an action which didn't require any actual evidence of state interference, paragraph 190. Or Tariq, tab 35, this court, government employee seeking damages following termination of allegedly discriminatory negative security vetting, voluntary employment, voluntary litigation, Lord Hope, paragraphs 75 and 81. This is in a completely different category to situations where the state is initiating interference with fundamental rights. So to case of X, tab 58, a police employee vetting damages claim. Kiani, tab 60, same context as Tariq. AZ, tab 62 and 63, an application by a refugee for a travel document to which he's not entitled. In tab 64, compensation for services rendered by interpreters in Afghanistan. Those are all cases in the other end of the spectrum, but where the state is not intruding on fundamental rights at all, and the litigation in question is at the behest of the party seeking to obtain something from the state. The issue for this court on this appeal is where on that scale or spectrum search warrants fall. On any view, and contrary to the judgment of the divisional court in this case, paragraph 33, Article 6 minimum disclosure category is not limited to cases which trench on physical liberty. That category is more nuanced than that. Search warrants may not trench on physical liberty in that narrow sense, but they plainly trench on civil liberties in the sense of fundamental rights. They plainly trench on personal autonomy. That is the meaning of the vast number of cases that impress the impact of search warrants on liberty. And however it is cast, the obtaining and execution of a search warrant is squarely within that category of cases to which irreducible minimum disclosure applies. If there is a test to be applied here, it's Lord Hope in Tarrick, paragraph 75 to 81. This is state-initiated intrusion on fundamental rights. If the nature of the fundamental right in question is relevant at all, this case ranks at worst alongside asset freezing and financial restriction orders, deprivation of Article 1, Protocol 1 rights. Property rights are high-level fundamental rights.
Well, that's putting it a bit high, isn't it? It's the asset freezing decision is on the basis that the effects were effective imprisonment. To have your property searched may be extremely upsetting, but it's not the same as being imprisoned or housebound.
Asset freezing cases don't of course say that they apply unless the assets involved are minimal. They apply because of the nature of the right in question and the right to property.
The reasoning is that they are extraordinarily swinging, which effectively restrict your every move. In order to spend any money at all, you had to get the Treasury permission in Ahmed, and so on. So that I think it's slightly, you may be putting it a bit high.
Well, if I put it too high, then I apologise. But our point isn't to diminish the effect of asset freezing or financial restriction orders. It's to explain properly the context of coming into a family home and ripping it apart. And at the risk of making a jury point, asset freezing cases don't involve coming in and cutting open the mattress that your child is sleeping on that morning.
And there's other time restrictions for these orders. I suppose they are.
For asset freezing, yes.
No, for search warrants.
Well, for search warrants, and this is a point that's made against me, you can only hold the materials for so long as the criminal investigation
time
is
of
alive.
Day and so on.
It has to be civilised. Section 16 of PACE imposes some limitation on that, but this is first thing in the morning when the children are still in the house, and those are the facts here.
Yeah,
The appellant's children here were aged 2, 5 and 15 at the time of this 3.5 hour search of his family home. The family home is within property rights, of course, the most revered. It's why the law applies wider margins of understanding to householders who defend the family home. Property rights are high-level fundamental rights. They trace from the Magna Carta and they wind through the centuries past Entick and Carrington all the way to present-day PACE. The consequences of a search warrant being executed are also in our submission on a different level from asset freezing, or at least potentially on a different level. They can provide the evidential foundation and directly lead to criminal prosecution, criminal trial, conviction, incarceration, and the holding of a criminal record. To characterise the interference represented by a search warrant as merely temporary, limited only to the time that the police can physically hold the material is in our submission blinkered. It fails to acknowledge the catastrophic effects that a search warrant can and often do set in train. They have potential to impinge on physical liberty, at least indirectly, and that's leaving aside the actual intrusion on the family home. In our submission, search warrants fall squarely within the category of cases to which Article 6 irreducible minimum disclosure applies. And reliance on cases such as IR against the UK, in which Article 6 wasn't even in play, or W. Algeria deportation proceedings in which no Strasbourg rights were in play at all, simply doesn't assist the court. Chapter 3. What if the appellant is right, and either closed process was impermissible at all, issue 1, chapter 1, or Article 6, irreducible disclosure is required, issue 2, at one or more stages? Well, we
Forgive
know...
me, Mr. Summers. Could I just ask you one question about A-type disclosure? Is it relevant to your submission that the issue to be considered is whether there was material on which the magistrate could come to a particular conclusion?
No. The issue to be... A-type disclosure attaches depending on the level of intrusion that we are talking about. It doesn't attach to the nature of the juridical process that then flows. So A-type disclosure attaches to situations where there is a trial of a state intrusion on fundamental rights, assuming that they are fundamental enough.
Many of the cases justify the requirement for A-type disclosure on the basis that it's necessary to be able to respond to the case that's put forward.
Yes.
But here we're dealing with a slightly different situation, aren't we? The question is not how to respond to that material, but whether there was a basis on which the magistrate could come to the particular conclusion.
And this, of course, is linked to the issue that we've already dealt with about how effective is judicial review without irreducible minimum disclosure. Can a judge properly do his or her function without knowing the other facts that have been omitted, without being in a position to understand the accuracy of the information before them? And the submissions that we've already made in a different context on that carry straight into this analysis, assuming that my lord is right and the nature of the trial and the review exercise is relevant to whether Article 6 applies in this context.
Thank you. I'm sorry to take you out of your course.
So, Chapter 3, we know that if disclosure is required, either because there's a closed process, is impermissible, or because Article 6 requires it, we know in this case that it cannot be disclosed consistently without doing damage to some public interest. What then? Well, the respondents argue that Carnduff and Rock should apply, and this case should then be struck out as untriable, or this judicial review should then be struck out as untriable. If correct, this would steer this case squarely into the deep waters that my Lord Mance ventured into in Al-Rawi, that is, closed procedure by consent, and whether consent in those circumstances is real. But it's not necessary to go there because Carnduff doesn't apply. No authority exists, and neither has it ever been suggested before that Carnduff could or should apply in a criminal case, and for good reason. Carnduff was an application for compensation for work voluntarily undertaken as a police informant, to which his cause sought to establish his entitlement and which he had initiated voluntarily. State wasn't engaged in depriving him of something which he already had, taking away something or some right which he already possessed. No case was being made against him. In such cases, whatever one may think of Carnduff, it returns the status quo. So in AHK, tab 37, an application for the grant of naturalisation was untriable because no closed process was permissible, and the application failed. The status quo was resumed. Al-Rawi, the application for damages presumably fails, absent closed process by consent. Now, that's certainly the assumption on which this court proceeded, because no closed process. In criminal proceedings, by definition, the position is always otherwise. It is the state that initiates criminal process, and in doing so intrudes on rights, here property rights, often liberty, which the defendant already enjoys. Returning the status quo, in this context, involves the state desisting in its intrusion. In such situations, there is ample and unbroken authority that the consequences of the state being unable or unwilling to make necessary disclosure of its evidence is that the state interference fails. So, for example, Roberts, tab 20, parole board decisions. In fact, in the end, a closed process was possible. But for the majority, it was expressly contemplated that had a closed process not been possible, the parole board would not have been able to rely on the material in question. The result would have been that the parole board would be deprived of the evidence, not that the applicant for parole, the criminal suspect in that case, would have been deprived of parole. So that's paragraph 83, subparagraph 4, Lord Wolfe for the majority. More obviously still in Davis, tab 22, if there can't be anonymity, but the law requires it, the result is that the prosecution fails, not that the defendant must live with it. Lord Brown at paragraph 66, the integrity of the judicial process is at stake here. This must be safeguarded and vindicated, whatever the cost. A against UK, tab 24, paragraphs 223 to 224. The result of irreducible disclosure being required but not being able to be complied with or given is release from detention of terrorist suspects. Not that the state intrusion persists. AF number 3, control orders. The result is state withdrawal of reliance on the material, and the control order is quashed. So paragraphs 24 to 26, Lord Phillips. 82, Lord Hope. 94 to 95, Lord Scott. The state cannot exercise its control order powers. Lady Hale, paragraph 106, the order cannot be upheld. And that's entirely proper and principled conclusion, according to Lady Hale. Lord Hoffman, even if it destroys the control order system. Paragraph 70. Lord Brown, paragraph 114, discharge of the control order. And that's even though national security is at risk, paragraph 121. Similarly, Cardi, tab 29, the freezing regulation is annulled. Not that the defendant has to live with the state intrusion fails. Bank Mellat, this court, even for the majority, the restriction order is discharged, paragraph 43. Back to control orders, Mohammed, tab 48, paragraph 17, the control order fails. The state's reliance on the evidence has to be withdrawn. Bank Mellat, number 4, tab 61, paragraph 37. The state is put to its election. Either doesn't rely on the evidence or it desists its intrusion. McVeigh, tab 65, paragraphs 25 to 27. the police are not in a position to justify an arrest, but the law requires them to, that's the end of detention. Put otherwise, the state is put to its election, disclose or desist. And the essential difference between the civil and the criminal context and the different imperatives that fashion the latter is the point that we understand Lord Mance was making in Tariq, paragraph 40, and again in Al-Rawi, paragraphs 101 to 103. In that context, the idea that there's some presumption of regularity that can serve to operate in the other direction is, in our submission, wrong. The usual position where the state interferes with human rights is that proof of the interference, here the existence of the warrant, requires or carries with it a duty on the state to justify the interference. The onus is on the state to justify interference. There are ample authorities for that. They are summarised in Fordham, the classic statement, of course, is Alico, no member of the executive can interfere with the liberty or property of the British subject, except on condition that he can support the legality of his action before a court of justice. And from that, in cases like Boddington, for example, the courts consistently place the onus on the state justifying infringements. There ought to be no presumption of regularity, at least in the criminal context. And insofar as Rossminster is potentially the source of such a presumption, it's a shaky start. Even the majority there conceived of some minimum disclosure to the applicant. And in any event, presumption of regularity cuts straight across Al-Rawi. If it had value or purchase, it would have been a complete answer to Al-Rawi. And neither, in any event, does a presumption of regularity, and this is perhaps most important for our purpose, cover the accuracy of the information given to a judge. Gibbs, tab 14, page 798.
Tab what?
Tab 14, page 798.
Thank you.
Even if there is a presumption of regularity, it doesn't tell the court anything about the accuracy of the information before the judge, and that's the principal evil to which closed process goes in this context. The judge just doesn't know whether he or she is being given the full picture or the accurate picture without the involvement of the appellant. So chapter 3, Carnduff does not run in the criminal field. So to our conclusions. Much of the submissions of the respondent and the intervener concern striking a balance between the public interest in effective criminal investigation on the one hand and natural justice, procedural fairness on the other. Their plea to this court, of course, is not to do anything which gives priority to the latter over the former, and they speak to the consequences of relegating the public interest in effective criminal investigation. And so, of course, did the divisional court, paragraph 41. I've already, I hope, addressed in short form whether those fears are real or otherwise. But the essential point to recall in relation to them is that the gist, that is the irreducible minimum disclosure required by Article 6, or the gist required by a closed process requires no more than the essence of the allegation. There's no requirement to disclose the evidence on which it's based or the sources of the evidence on which it's based. A against UK, paragraph 220. AF, this court, tab 26, paragraphs 66, 86, 103, 120. Bank Mellat number 4, tab 61, paragraph 33. Paragraph 33, all make that point. That all we are talking about, all we are talking about in this context is giving the appellant a gist that discloses the essence of the allegations against him.
And on an application for a search warrant, that is what?
That is a gist of the allegations
We think you may have committed offences of, shall we say, drug dealing, and we have information of drugs in your house. We want.
Well, that's a lot more than this appellant knows about the warrant.
But is it enough?
That decision will ultimately be fact-specific, but it potentially could be.
I see.
He would know why his house was being invaded. He would know the essence of the allegations against him, even if he weren't to know the evidence that supports it or the nature of the sources from which it is drawn.
But this section only authorises a search warrant if a justice of the peace is satisfied that there are reasonable grounds for believing that an indictable offence has been committed, that there's material which is likely to be of substantial value to the investigation of the offence and likely to be relevant evidence, etc., and doesn't consist of legal privilege. What you're postulating is, seems to me, a sort of halfway investigation of whether the section is satisfied, because you accept that you don't get the material which would enable the justice to know whether or not there were reasonable grounds. In other words, the gisting exercise, if you really confine it to the bare statement about what offence you think has been committed and what material you think is there, really doesn't help very much.
Well,
it gives you a limited basis of challenge, but it is a rather limited one.
The gist that we say is required, is that which the magistrate relied upon to be satisfied that the statutory conditions are made out. And if this court comes to the conclusion ultimately that the magistrate's reliance and answer of those issues is a wider exercise, and one that has to take into account the source of the evidence,
one would have thought it
the
did.
intelligence, then that's what's required.
I see. So it's got to go further. Yeah.
And what's not required by any court is for the various public interests to be weighed or balanced. Chapter 1, Issue 1, is an issue of jurisdiction. It's a matter of common law. The weighing of the public interests is for Parliament. Al-Wawi says that if the public interest in criminal investigation is to take priority, Parliament can and will so provide for closed process. The issue for this court is whether Parliament has done so. Parliament dictates the balance. It's not for this court to do so. Issue 2 is Article 6, minimum disclosure. The weighing of the public interests there is for the Council of Europe and the Strasbourg Court. It has done so in A against the UK. If this case is within that class of cases where Article 6 requires irreducible minimum disclosure, that is the answer. Article 6 dictates the balance. It's not for this court to do so. AF number 3, paragraph 50, Lord Phillips, with whom all agreed. Issue 3, Carnduff. This is the sole area where the court could impose its own assessment of the balance by denying the appellant relief rather than denying the state its intrusion. But that would be a novel and fundamentally wrongful extension of that jurisdiction. It would represent a development of the law that would, A, cut across the consistent approach of the lower courts, the House of Lords, and the Strasbourg Court, all of which are predicated on the state desisting its intrusion. It would shut down substantive judicial review and diminish the rule of law. It would cut flatly across the place that common law principles of natural justice generally hold in the criminal arena. Davis, this court, there can be no anonymity at trial, however heinous the allegations, double murder there, and despite the consequences of that, there the extreme threat of witness intimidation to the administration of justice. And to allow Carnduff to roam in the criminal field would have potentially profound and unforeseeable consequences for criminal judicial review and therefore potentially for the criminal law generally. Carnduff ultimately rested on the proposition that the public interest at stake there outweighed the public interest in doing justice. That is not a permissible conclusion in a case where either Parliament has outlawed closed process or not permitted it, or Article 6 dictates disclosure. And ultimately, it's no coincidence that in those cases that restore the status quo under Carnduff to dismissal of the underlying claim, those cases are where the Article 6 principles don't run. The converse is always true. Where the state intrudes on fundamental rights, it's that intrusion which is refused. Applying Carnduff otherwise would render Article 6 minimum disclosure and its standards of procedural fairness meaningless, would circumvent the effect of Article 6 by substituting this court's assessment of the weight to be attached to the public interests. Ultimately, we say that the court can and should restore the healthy dilemma that Lord Kerr spoke of in Al-Rawi, paragraph 96. Non-disclosure leads to the failure of state intrusion. It therefore carries with it an incentive to disclose, rather than, pursuant to the judgment in the present case, non-disclosure leads to immunity of executive action from judicial review and carries with it an incentive to secrecy. For all of those reasons, in our respectful submission, this appeal should be allowed, unless we can assist further.
No, thank you very much indeed. Ms. Jones. Thank you. Yes. Chamberlain.
My Lords, my Lady, on behalf of the Chief Constable, I'd like to make submissions on each of the 5 agreed issues in the case. I'm going to do so in order. Before I do that, I want to say a word about the way in which those issues came to be agreed and why we say the court should address them all. The court below did not consider issue 1, which is the limits, if any, on the powers of the magistrate, as a distinct issue. The reason why the appellant and respondent agreed that it should be formally recognised as an issue before the court was because it's a necessary building block in answering the other questions. In particular, if the magistrate cannot grant a warrant where the information supporting it consists entirely or to a decisive extent of sensitive material, then neither, presumably, can the Crown Court on an application for an order under Section 59(6) of the Criminal Justice and Police Act. If, on the other hand, the magistrate's powers to grant the warrant on the basis of sensitive material are not limited in the way Mr. Summers suggests, that is itself highly relevant to the question whether those of the Crown Court judge are limited, particularly if, as we say, the Crown Court judge stands under the Act in the shoes of the magistrate. Now, issues 2 and 4, which are about the powers of the High Court on an application for judicial review from respectively the magistrates and the Crown Court judge, did not strictly arise for determination by the Divisional Court because that court found it unnecessary to consider any closed material. There was a discussion before the Divisional Court about whether it should look at closed material or not, and in fact the police was offering to show the court closed material, and the court declined to look at closed material. It said it wasn't necessary to do so. So that means that this court could, in principle, properly resolve this appeal without resolving issues 2 and 4. But the Divisional Court did certify those issues as ones of general public importance, and they are closely connected to the points that the court does have to determine, and we do therefore invite the court to determine them. With that introduction, can I go straight to issue 1, which is what, if any, are the limits to the jurisdiction of a magistrate's court to rely on evidence not disclosable to the subject of the warrant in an application made ex parte for a search warrant under Section 8 of PACE. Now, before I go to our legal points as to why we say there are no limits on the jurisdiction of the magistrate to consider material which is sensitive, I want just to try and address some of the questions which have been put in argument by my lords and my lady to Mr. Summers. I want, in other words, to try and put this case in its factual context. So take an example. There has been a murder. Someone comes to the police and says that she saw Mr. X on his way home with a bloody shirt. That someone fears that if Mr. X finds out that she's told the police what she's seen, she'll be in danger. That's just one example. It could be a murder and a bloody shirt. It could be a bag of heroin, as we've set out in our case. It could be terrorist bomb-making equipment that has been seen in someone's house. Now, what happens now if that someone comes to the police and tells them that this has been seen, is that the police officer will have to assess the reliability of the source. Who is the person that's given this information? And the police officer will expect, when he or she goes before the magistrate, to be quizzed about the reliability of the source. Why? Well, it's a point that was put in questions to Mr. Summers by Lord Hughes. Well, because the fact that someone has told you that Mr. X was seen with a bloody shirt may or may not be a good reason for granting a search warrant. It depends who that someone is. Is that someone a person whose information can be relied upon? And that's precisely the kind of questioning that you would expect to see taking place before a magistrate conscientiously discharging his or her responsibilities under Section 8 of PACE. For example, the someone who told me that Mr. X was seen with a bloody shirt is a family member of Mr. X, or the someone that told me that a bag of heroin was to be found at this address is a reliable informant who has provided correct information to the police on 3 previous occasions, which I can now identify. That's the kind of discussion that you would expect to see before the magistrate. Now, what does Mr. Summers say happens in a case like this? Well, he has 2 possible answers as I understand it. The first, which certainly was an answer that he gave on a number of occasions during his submissions, is that the warrant simply can't be issued. One has to assume, of course, in all of these examples, as Lord Mans said in questioning, that this is the only information that the police constable has to justify the warrant. One has to assume that because that's the case we're dealing with. We're dealing with the case where the warrant is based either wholly or to a decisive extent on information which cannot be disclosed, because to disclose it would put someone's life in danger or would otherwise damage the public interest. So Mr. Summers' first answer to the question what happens is no warrant. So the murderer house or the suspected murderer's house cannot be searched. The fact that bomb-making equipment has been seen cannot be taken further. The bag of heroin has to be left where it is. The second answer really reveals what a bizarre submission my learned friends is with respect, and that is that the police officer can say simply to the magistrate, well, someone told me this. I have information, this is the way he put it, and I wrote it down, but I can't tell you where that information is from. Now, the reason I say that's a bizarre submission for Mr. Summers to be making is that it suggests or entails a lesser degree of scrutiny than would currently occur. In other words, it suggests that the magistrate should be kept in the dark about the true nature of the information, should be prevented from asking the question, well, come off it, officer, that source doesn't sound very reliable to me. And the position is simply that the information has to be given in the very simplified, and we would say not at all informative way that Mr. Summers suggested. Well, now we say this isn't how the position has ever worked in practice. It's not what is suggested by the criminal procedure rules, and it's not mandated by the Act. Can I start with the criminal procedure rules? Because this was a point which was taken, as I understand it anyway, for the first time in oral argument, although I'll be corrected if I'm wrong. But the submission was, as I understand it, based on Rule 47.26, which you have in Authorities Bundle 1, tab 3, MS 554. So I just ask your lordships and your ladyship to look at that for a moment. And in particular, it's 47.26.4. And this is a rule which says that where the application includes information that the applicant thinks should not be supplied under Rule 5.7, my Lady Black asked the question, well, that's a very important qualification under 5.7 because this rule is looking forward to the point where an application may be made at a later stage for disclosure. And then if we see what it then says, the applicant may set out that information in a separate document marked accordingly and explain why it ought not to be supplied to anyone other than the court. Not must, but may. So what this rule is doing is it is saying if you know and you can foresee that you have information which is going to attract public interest immunity at a later stage, that issue doesn't arise before the magistrates on the ex parte application, but it may arise at a later stage when an application is made, as my lord put it, under Rule 5.71, disclosure. Then, as a matter of convenience, you can put that material in a separate document so that it's clear from the outset that it's material over which you claim PII. But if we then go to Rule 5.7, as my lady suggested we did, we find that it is...
Is this 5.7 of the criminal procedure rules?
Yes.
Because what we've got in the documents is the civil procedure rules, or at least it's said to be. But it may well be there's an exact equivalent. I don't know.
I see. Well, in that case, I'm afraid I had made the erroneous assumption, which I think your lordship may have
no
corrected
doubt it's there
now,
somewhere. It's only a question of finding where.
that we were looking at indeed. We were in fact looking at the 5.7 referred to here. But
Just remind me where he is.
my
Where
lord,
is 5.7?
81.
well, I had thought that it was in
Tab 75,
75 in Authorities Bundle 6.
Very like the criminal procedure rule.
Sorry?
That is the criminal procedure.
Yeah.
It is it?
Yes, it
Because
is
I
the
had
criminal
looked at it
procedure rules.
elsewhere
Yes.
and-
Yeah.
It's tab It's tab 81, I
In
think.
case it's exactly the same as the civil procedure rules. Yes, fair
Yes.
enough. It's labelled civil procedure rules in the index, but that's just a simple error.
It's the same, yes. So if one then looks at tab 81, which is at page 2785, attention was drawn by my Lord Mans to,
Sorry, tab, page...
I'm sorry, 2785.
Yeah, right.
Attention was drawn by Lord Mans to sub-rule 8 and 9. One can also look at sub-rule 6, where the information requested is about the grounds on which an order was made
Yeah.
or a warrant was issued.
So that probably, I think Lord Hughes and I spotted that, or Lord Hughes did afterwards. And
Yes.
that seems to be consistent with my suggestion that 8 and 9...
So it's totally clear that, of course, this is only secondary legislation, and I have to answer the question whether this secondary legislation and the process which has been unfolding before magistrates for very many years without challenge is all ultra vires because of my learned friend's point, and I will address that point in due course. But the current position, as it has been understood and as reflected in the civil procedure rules, is that it is not at all unusual for an application to be made, for an ex parte application to be made before a magistrate for a search warrant based either entirely or to a decisive extent on material which it is known will attract PII at a later stage when that question becomes relevant. Now, moving then to the substance of the legal issue, which is, well, does the statute in fact confer power on the magistrate to consider material which will not be disclosable at a later stage? We say plainly yes, and the best answer to that question comes from a case which Mr. Summers did not show you, but it's the only case in the bundle which deals with the application of al-Rawi to PACE search warrants, and that's the B Sky B case. And the B Sky B case is in Authorities Bundle 4 at tab 46, MS 1874. Now, just to put it in context, we've set out in our case in some detail the difference between the different kinds of warrants that can be applied for under PACE. There is what I'll call the bread and butter Section 8 search warrant, which is what we're dealing with here. But then there are other species of warrants to which a different procedure applies and different statutory provisions apply in the schedule to PACE, Schedule 1. And we've set out in our case in some detail the differences between these two types of warrants. Now, the issue in this case, the B Sky B case, was whether a warrant under paragraph 4 of Schedule 1 to PACE was, or an application for a warrant under paragraph 4 of Schedule 1, was the type of proceeding in which closed evidence could be entertained. That's the issue in the case. And what the Supreme Court did in that case is they looked in some detail at PACE and at the different procedures in PACE for warrants. And can I take it up at the end of Lord Toulson's judgment, paragraph 28 on MS 1876. He says this, as a general proposition, so we're dealing here with a special procedure warrant which is required by statute to be made inter partes. That's paragraph 7 of Schedule 1. So it's an express requirement on the face of the statute that the application must be made inter partes. And that's because these are applications which are generally made against accountants or solicitors or banks for material which is subject to duties of confidentiality vis-à-vis the subject. And at 28, one can see Lord Toulson saying this: as a general proposition, I would agree with the Commissioner's argument that the court should not apply the al-Rawi principle to an application made by a party to litigation or prospective litigation to use the procedural powers of the court to obtain evidence for the purposes of the litigation from somebody who is not a party or intended party to the litigation. This is because such an application will not ordinarily involve the court deciding any question of substantive legal rights as between the applicant and respondent. Rather, it's an ancillary procedure designed to facilitate the attempt of one or other party to see that relevant evidence is made available to the court in determining the substantive dispute. Applications of this kind, such as an application for a witness summons in civil or criminal proceedings, are typically made ex parte. However, the present position is different. Compulsory disclosure of journalistic material is a highly sensitive and potentially difficult area. It is likely to involve questions of the journalist's substantive rights. Parliament has recognised this by establishing the special, indeed unique, procedure under Section 9 and Schedule 1 for resolving such questions. Ultimately, the issue in this appeal is a short one. It turns on the meaning and effect of paragraph 7 of Schedule 1. Parliament recognised the tension between the conflicting public interests in requiring that an application for a production order shall be made inter partes. The government had originally proposed that a production order might be made ex parte, but that proposal met opposition and was dropped. When an application for a production order is made, there is a list between the person making the application and the person against whom it is made, which may later arise between the police and the suspected person through a criminal charge. Equal treatment of the parties requires that each should know what material the other is asking the court to take into account in making its decision and should have a fair opportunity to respond to it. That is inherent in the concept of an inter partes hearing. Now, in this case, we are dealing not with an application required by statute to be made inter partes, but with an application required by statute to be made ex parte. I'll show you the section in just a moment. But we do say that the B-Sky B case is powerful authority against my learned friend's submission on issue 1, because if inter partes equals full disclosure, then an express statutory requirement for ex parte may be thought to indicate the reverse. That's obviously just one point, and I accept, of course, it's not on its own determinative. But can I ask your lordships and your ladyship to look at the Act itself, which is in Authorities Bundle 1, Tab 1, MS 509. And this is Section 15 and 16 of PACE. Now, I'm not going to read it, but you can see that there is nothing in Section 15 which expressly limits the information on which the constable may rely to disclosable material. And 15.3, as I've said, says an application for such a warrant shall be made ex parte and supported by an information in writing. And we say the effect of that is that at that stage Parliament intended and envisaged that there would be no lists of the kind referred to by Lord Toulson in the proceedings. Perhaps more importantly, there is then Section 16 over the page. In fact, it's over a couple of pages on MS 512. And that sets out the various safeguards which Parliament imposed on the execution of warrants. And if you look at 16.5, you can see that where the occupier of premises which are to be entered and searched is present, the constable has to do 3 things. He's got to identify himself or herself, produce the warrant, and supply a copy of the warrant. Parliament obviously could have added to that a requirement to give the information on the basis of which the warrant was granted, or a summary or a gist of it, but it didn't add that requirement. Now, of course, we accept that there are cases where the common law can supply the omission of the legislature. And indeed, there is quite a bit of case law in this area dealing with the circumstances in which disclosure should be given of the information supporting an application for a warrant. But that case law properly balances two public interests. It balances the public interest in protecting the personal and property rights of citizens against invasion on the one hand, against the public interest in the effective investigation and prosecution of crime on the other. And that is why there is express recognition in the case law that on an application made post-execution of the warrant for the information on which the warrant is based, some or all of the information may have to be withheld for good public interest reasons. Now, that is recognised in a number of different cases, and I'll take you to them relatively quickly, if I may. The first is Lord Wolfe in the case of Cronin, which you have in Authorities Bundle 1, tab 18, pages 849 to 850. Right at the bottom of 849, in paragraph 29, you can see this from Lord Wolfe. A suggestion was made as to whether it be desirable to provide information unless there was some legal justification for doing so. And Lord Wolfe gives a qualified yes to that, but he says this, he says, information may contain details of an informer which it would be contrary to the public interest to reveal. The information may also contain other statements to which public interest immunity might apply. But subject to that, if a person who's in the position of this claimant asks perfectly sensibly for a copy of the information, then speaking for myself, I can see no objection to a copy of that information being provided. So that's the first recognition in the case law of the right to see a copy of the information. And you can see that it's expressly made subject to a carve-out for information which is subject to public interest immunity.
Which stage of the process is he speaking, Mr.
He's speaking about an application for disclosure of the information post-execution of the warrant. So what happened in the case law is that, first of all, there's a recognition here in the Cronin case that one is entitled to ask, once the warrant's been executed, for disclosure of the information on which it was based. This is absolutely not dealing with the initial ex parte stage. Well, it couldn't be because it's an ex parte application and required to be so by statute. Subsequently in the case law, the cases recognise that there may be a requirement if there's a dispute about what ought to be disclosed and what should be withheld, for that dispute itself to be judicially determined. And eventually the view is taken, well, that dispute ought to be brought back to the magistrates. And then there was a question, well, do the magistrates have jurisdiction or are they functus officio? And the answer is no, they do have jurisdiction, so that if there is a dispute about disclosure of the information, that itself goes to the magistrates under what is called the Bangs procedure now. And the magistrate will then have to decide which of the information is properly subject to public interest immunity and which can be disclosed. But can I show you, before we go to Bangs, Lord Justice Kennedy in the Energy Financing Team case, that's Authorities Bundle 2, tab 21, MS 941. And there's a whole series of propositions which 9 and 10 are on pages 941. I'm not going to trouble you with any of them apart from number 10, but if one looks at 10 next to letter C, Lord Justice Kennedy says this: often it may not be appropriate, even after the warrant has been executed, to disclose to the person affected or his legal representatives all of the material laid before the district judge, because to do so might alert others or frustrate the purposes of the overall inquiry. And that's another theme. So aside from the case of informants and so forth, that's another theme that comes through the case law, which is that we are dealing at the stage of an ex parte application under Section 8 with potentially the very early stages of a criminal investigation. To disclose at that stage the information on which the warrant was based might reveal all kinds of things about the investigation, which would then undermine it.
And just going back to what Lord Toulson said, you say that present is not a case where we're concerned with a specific issue set up between the Crown and a specific category of people like journalists in relation to their information. This is just a case where, in fact, there was the material wanted or which was of interest might have had to do with a third party, for example. Indeed, I think in the case of one of the searches was of company premises. So presumably the material there was sought with a view to prosecuting some individual, probably Mr. Haralambous himself, but in relation, the actual search was of the company premises.
Yes, and my Lord, obviously I'm not going to go into the facts of this case beyond what's on the documents, but of course your Lordship is absolutely right as a matter of generality.
Yeah, I'm just testing the proposition. There's no reason to believe that it was necessarily concerned with him or anyone.
No, and one of the points that we will see...
But that's true, whether it's, as it were, standard material, Section 8, or excluded or special procedure material, Section 9. It might be in the hands of anybody. What matters is the character of the material, isn't it?
I agree with that, but the distinction that was made by Lord Toulson in the B-Sky B case between the two sorts of application is that the specific features of the special procedure application, the particularly sensitive rights in play when the police go after journalistic material or accountant's material or bank documents, are such as to justify a procedure which Parliament specifically prescribed. And there is a different procedure here. And that point was obviously... It's
because they have the different interests that my Lord's identified.
Yes, indeed.
Not that they're at risk of prosecution, but that they've got a journalistic or a professional interest.
But the risk of alerting other people is something that we will see in the later authorities. So that point that my Lord puts, that there is a risk that an application for a Section 8 search warrant may well be intended to reveal information which has got nothing to do with the subject himself. It could be other people. That fact is, you will see, a consideration to which the House of Lords had regard in the Rossminster line of cases, which we'll see in just a moment. So that's the EFT case. You'll see just above letter D, what is said there by Lord Justice Kennedy is that the individual ought to be told what happened at the hearing, and there should, important caveat, so far as possible, be an accommodating response to that request.
This is what you've got to deal with. The bit before that
Yes.
Might alert others and frustrate the purposes of the overall inquiry, etc.
Yes.
But the person affected has a right to be satisfied as to the legality of the procedure which led to the execution of the warrant.
Yes.
And what I think is said against you is that if it's entirely based on material which can't be disclosed, then he never can be.
Well, can I try and answer that question by reference in a moment to the Rossminster line of cases, because they deal precisely with that issue. And it was suggested, I think, in argument at one stage that the Rossminster line of cases was somehow closed material cases. They're not closed material cases at all. They're cases that explain what happens when the court cannot look at closed material, and that what the magistrate could, or the person giving the warrant or notice could, And they explain very carefully that you're not shut out from seeking judicial review. You can still make your submissions before the Judicial Review Court. But in the Westminster line of cases, it is said the one thing you cannot do is assume, contrary to what you know to be the fact, that there was no material before the magistrate other than that which you can yourself see. Now, I'm going to show you that line of cases in just a moment. Before I do that, can I just show you very quickly two further references before we break. The first is Lord Justice Gross in the Gittins case. That's in Authorities Bundle 3, tab 31, MS 1385. And that's at paragraph 28. By their nature, criminal investigations are such that there will be occasions when, for good reason, HMRC or other authorities, as the case may be, will not be able to divulge the full information or the full contents of the discussion before the judge who granted the warrant. There is an important public interest in combating economic crime, and HMRC's proper efforts to do so should not be undermined. And then at 29, he makes the point, which we don't quarrel with at all, that HMRC or whichever investigatory authority should be in a position to justify that stance by reference to the facts of the individual case. So you can't simply come along and say there's a general policy against disclosure of matters to do with an investigation. You have to give chapter and verse as to why in this particular case it would be contrary to the public interest to disclose the matters which you're seeking to withhold. And you have to convince the judge, the magistrate, or if it's in the Crown Court, the judge, of that fact as well. And that's what happened here. You'll know that there was the initial application for the Section 8 search warrant before Ms. Grimsey, the Justice of the Peace. Then there was an application which went before District Judge Mellenby, and she considered in detail the submissions of the police, that it was proper to withhold certain of the material, and she upheld that submission after looking at the material and forming a view about it herself. And indeed, that process was undertaken again before His Honour Judge Bright, and he too came to the view that it was not possible to disclose any of the material. So that is what Lord Justice Gross is saying. If one looks at paragraph 30, where full disclosure cannot be given, brackets, and there will be cases where it cannot be, HMRC should, if at all possible, and again, unless there is good reason for not doing so, make available and in a timely fashion a redacted copy or at least a note or summary of the information and the hearing before the judge. So that's the way in which the two public interests are reconciled in these authorities. I'll see the time and therefore perhaps ought to stop there, but I'm going to come to Bangs after the adjournment.
We'll look forward to hearing your further submissions then at